Part 3. Which type of guardianship is needed? All adults are deemed under the law to have the right to make their own decisions. A guardian is a surrogate decision maker appointed by the court when the individual has not previously designated someone to make decisions for them, in the event they cannot make their decisions for their own well-being. The reasons why guardianship would be necessary for adults include: some individuals may have limited capacity to make or communicate decisions, where they need someone else to make certain decisions. And some may be susceptible to fraud or undue influence. Only a court can have an individual's rights legally taken away. Courts will remove only those rights that the proposed protected person is incapable of handling. Which type of guardianship is needed? There are basic differences in guardianship, conservatorship, and mental health treatment guardians. Guardianship for the person is called a guardian and may also include responsibility for routine financial matters and may be full or limited as needed. A probate guardian is assigned by the court to make decisions on housing, services, non-mental health decisions, benefits, and routine matters. Guardianship for the estate, property, and assets is called a conservator. A guardian for mental health treatment is called a mental health treatment guardian. An individual may need all three, and they are processed under different state laws. Priority is given to an agent designated or nominated previously by the client when they had capacity, or to family members vetted by the guardianship process for this responsibility. Who should be selected as a guardian? The court selects the best qualified person or entity to serve as the guardian for the best interest of the incapacitated person and for good cause shown. The first priority is for an agent designated or nominated previously by the clients when they had capacity. This is followed by the spouse, adult child, parent, person nominated by will or other writing by a deceased parent, relative with whom has resided for 6 months prior to petition, someone nominated by the person who is carrying or paying benefits for the incapacitated client, or any other person. A possible guardian needs to be vetted for the best interests of the protected person. Sometimes they aren't capable of making the decisions for the protected person. They can't be reached. They have a conflict with a proposed protected person, or there may be other disqualifying reasons against someone being appointed as the guardian. Trained guardians and mental health treatment guardians may be paid by available resources, or as a last resort, paid from public funds from the state guardianship program. It is preferable, but not mandatory, that the guardian be appointed by the court in the judicial district where the client resides. Guardians have a fiduciary responsibility with a protected person, which is a position of confidence, good faith, reliance, and trust. This is not a personal relationship. Professional guardians use person-centered principles to tailor decisions to the individual, which involves protecting while advancing their dignity, respect, and independence. Allowing the person to explore, learn, grow, and experiment as do all individuals. Using substituted judgment to try to make the decision the person would make for themselves if capable, based on available knowledge of prior decisions, personal values, and advanced directives. Seeking guidance from the judge with extraordinary decisions. Acting at all times for the sole benefit and interest of the protected person. Mental health treatment guardian or probate co-guardian, or both. Let's explore when each of these types of guardians are appropriate. Treatment guardians provide informed consent only regarding mental health, psychiatric treatment, or medication, and does not extend to other physical health problems. Mental health treatment guardians are appointed by a district court under the Mental Health and Developmental Disabilities Code and are appointed to a maximum of 1 year. The court specifies the length of time and is subject to renewal by the court. This is for those who are temporarily unable to make their own decisions about mental health services. The Mental Health Code of New Mexico states that if a client is capable of giving informed consent, then their consent must be obtained before performing extraordinary treatment or any other mental health treatment. When informed consent cannot be given, then the court will appoint a treatment guardian who will make a decision for them. A treatment guardian makes decisions about authorizing disclosure of confidential information, such as mental health medical records, when the client cannot provide informed consent regarding disclosure, and must take care not to disclose information prohibited under confidentiality laws. For outpatient clients who refuse to comply with their treatment guardian's decision, the treatment guardian may seek an enforcement order from the court. This order may authorize a peace officer to take the person into custody for transport to an evaluation facility, and may authorize forcible administration of treatment. Probate code guardians are referred to as guardian of the person, and they make decisions per the court order, which include arranging and monitoring of placement, housing, services, medical decisions other than mental health treatment and medication, benefits and routine financial matters. However, this guardian is not necessarily the representative payee for Social Security benefits or the fiduciary for veterans benefits. A probate code guardian can also make mental health treatment decisions, but only if specified in the court order, or may also be appointed as a mental health treatment guardian. Likewise, a treatment guardian may also be appointed as full or limited guardian under the Uniform Probate Code. There's also guardianship for the estate related to property and assets, which is called a conservator. A protected person may need all three types of guardians based on the decision-making needed: income, property, and assets, and it may be the same person. There are some basic similarities, but also differences in getting a mental health treatment guardian appointed versus a probate code guardian. The similarities include that an interested person may petition, although for treatment guardians, it is generally done by a physician or mental health or developmental disabilities professional. Another similarity is that the client is represented by counsel for a treatment guardian and by a guardian ad litem, GAL, for a probate code guardian. A major difference is that a treatment guardianship is effective for a maximum of 1 year, but is renewable, where a probate code guardian may be temporary or permanent. Treatment guardian hearings are held within 3 court days. The treatment guardian only has authority to make decisions related to mental health and may seek an enforcement order. And the probate code guardian makes decisions under the authority given in the court order, which may be plenary, full, or limited, specified. For probate code guardians, the court appoints a court visitor and a qualified healthcare professional. As covered in Part 1 of this video, we encourage making preparations in advance, such as preparing advance directives and powers of attorney, setting forth what they would want and not want, and who should make decisions for them in the event the individual is unable to make or communicate decisions for their own well-being. In summary to this section of the video, the type of guardianship appointed by the court depends on what types of decisions the protected person needs help to make.